say you fired them because they complained. And the fourth topic is privacy, specifically the ADA. In other words, if some employee says, you disclosed my COVID information, you violated my privacy, I want to sue you. So the class or the seminar is in four basic parts, about 15 minutes each. So let me start with workers' compensation. I think everybody knows basically what workers' compensation is. That is, if you have an employee who gets hurt on the job during the course and scope of their employment, they can't sue you. They'd like to sue you, but the workers' compensation law says they can't file a lawsuit against you. They're limited to their workers' compensation legal remedies. What does that mean? That means they file a workers' compensation claim. What does that mean for you? You turn it over to your insurance company. You have to carry workers' compensation insurance in Pennsylvania to be legal. A lot of people don't know this. If you don't have workers' compensation insurance, it's like driving your car without your little card that you get every 6 months or whatever. Okay, so generally you turn it into your insurance company, they handle it. But hey, if there's a claim and you have to pay, the next time you get your insurance premiums, they're going to go up. So you have some skin in the game. Basically, in workers' compensation, an employee has to prove that they were number one on the job, that they got the virus when they were on the job. And number two, and that's not enough. Number two, they have to prove that they need medical treatment, they need medical bills paid for, and or they can't work because they're sick, and therefore your carrier has to pay them. Okay, so the way it works is from the time an employee thinks he or she is sick from the virus and can't work, they have to notify you within 21 days, and then you turn it over to your insurance company. Okay, how does one of these cases get proved? What does the employee's lawyer have to prove if the insurance company doesn't want to pay? Well, like I said, the first thing they have to prove is they were on the job. Okay, the second thing they have to prove is they got the virus on the job. Okay, now I know lawyers like to terrorize their audience. The game is we terrorize you, and then when you get in trouble, you come running to us. So we get business by terrorizing you. I don't do that. I'm here to tell you that I don't think there's much workers' compensation exposure for COVID. Okay, so maybe I'm hurting my bottom line or whatever, but I'm telling you the truth. And here's why. It is going to be very difficult for an employee to prove that they actually got the virus while on the job. Why? Well, because you haven't figured out the virus is pretty darn microscopic, okay? It's not like an employee hurt their back and they can say, here, you know, there's the video. I broke my back walking down the steps. You have to pay me workers' comp, okay? The insurance company doesn't want to give their money up, and so their doctors, if push comes to shove in front of a workers' compensation court, they're going to say, hey, how can the plaintiff prove that they got the virus on the job? Maybe they got the virus when they went to Sam's Club or Walmart or whatever. And the lawyers out there know that. I look at the chatter, you know, the lawyer chatter every day on the internet. And the workers' compensation lawyers would love to file claims against you, but they know it's going to be very difficult. Just because, you know, an employee says, hey, you know, I found out that somebody else at work had the virus, I got the virus, you know, A plus B equals pay me. It doesn't work that way. Specifically, in a workers' compensation claim, the employee is going to have a doctor who's going to have to testify in court to a reasonable degree of medical certainty that they got the virus on the job. It's going to be difficult to do. Now, because of that, the chatter on the internet among the lawyers is they're looking for an easier way, and that's called an occupational disease. An occupational disease is the alternative way they can file a workers' comp claim against you. The best way to explain an occupational disease theory is to give the most common examples. Asbestos, dust, and coal dust. Everybody knows you don't get sick from asbestos with just one puff. It's accumulation of years, same thing with coal. And so if you're a steel company or a coal mine or whatever, and an employee can't breathe, they have breathing problems, they can file a workers' comp claim. And then there's like an easier way to do it, a lesser hurdle. What they'll say is, I'm relying on the occupational disease theory, and I just have to prove that the industry I was working in has a higher disease rate, okay? And therefore, I probably contracted it, okay, either in the coal mine or as an insulation worker. And that sounds easy, and I think that would be, you know, easier to fit. The problem for the employee's lawyer is that if you read the statute, COVID isn't listed as one of the recognized occupational diseases, okay? The lawyers know that, and so what they're doing as we speak, they're trying to come up with creative ways to get around that. There's actually some legislation that's pending in Harrisburg. They're trying to get the liberals in Harrisburg to relax the legislation to include COVID as a specifically recognized occupational disease, okay? That's really the silver bullet, okay? And so really, you know, for them to win, it's got to be through politics, because right now I think it's going to be very difficult for an employee to successfully file a workers' compensation claim against you because they contracted the virus. Now, go ahead.
Okay, hang on. I want to just clarify a couple things.
Yeah.
Because I want to make sure that I understand what you're saying. So, somebody's on the job. An employee of yours has gotten COVID,
right,
and they claim, I know that I got this when I was at work, or maybe whatever they think or are trying to do. What you're saying is that they can't just sue you. Like if they got an attorney, they can't just say, I want to sue my employer. They have to go through workers' comp for that. Is that correct?
And that's actually
okay.
Go ahead. You have
now.
Go ahead.
Yeah. But right now that wouldn't be covered unless there are some changes, like some of the things that they're trying to do. But then my question is, you know, it makes sense to me to say, you know, if I worked in an environment where asbestos or coal would be that could be considered an occupational disease. Are they trying to get this like a blanket kind of thing for every business, or say that like if I'm in medical or if I'm in retail and have all of this exposure to the public? What are they trying to do right now?
Sure. The standard way for filing a workers' compensation claim is the employee has the burden of proof. The employer doesn't have to do anything. The employee has to prove that he actually broke his back or twisted his knee or whatever, okay?
Okay.
The easier route is the occupational route, okay? Like I said, it pertains to specific injuries. COVID right now isn't recognized. But if COVID gets recognized, then the difference is the employer starts out guilty.
Oh, great.
It's presumed that he got COVID in the workplace, and then you have to disprove it, okay? Which is why, you know, we have all these asbestos claims or whatever. And so again, the plaintiff bar recognizes that, and they're trying to get the law changed. Now, one other aspect of the workers' compensation law, which we need to talk about before we go into the second topic, OSHA, it's one of the nice things about the workers' compensation statute is there is immunity from being sued, okay? So let's just say some dumb lawyer who doesn't understand these laws, and believe me, there are a lot of them out there, sues you, doesn't know anything about workers' compensation, he just types up a nasty lawsuit and sues you. Your lawyers will get the case immediately dismissed, thrown out of civil court, because they'll assert the workers' compensation defense. They'll say, hey, I read this lawsuit, judge, and this plaintiff is saying he got it when he was at work. You don't have jurisdiction. This is a workers' compensation case. And so the judge says, fine, thank you very much. I don't have to decide the case. I dismiss this case. And then the employee has to go over to workers' compensation court, which is a completely separate court. And then he has to face the hurdles I've talked about, okay? Now, having said that, not to scare you, I said I wasn't going to do that. The plaintiff lawyers know there's money to be made out there, and they know what the hurdles are. So there's a test case now as we speak in Philadelphia, and some really, really bright Philly lawyers were very creative. They wrote this big, long lawsuit, and they came up with this long horror list of everything that this meatpacking plant employer did wrong, ignored the CDC guidelines, you know, didn't allow social distancing, refused to issue PPE, didn't allow his people who were sick to take sick leave. I mean, it was, you know, it's like a poster child for being a dumb employer. And so what
is this the case, just to orient people, is this the case where it was a meatpacking plant and the person got COVID and they died, and now it's like a...
Oh, yeah.
Okay. Yes. Okay.
And so what these creative lawyers in Philly are doing with this test case is to say, listen, the only exception to the workers' compensation defense is if we can prove that the boss intentionally killed the employee. It's called the intentional act exception. If it's just alleged that this employee got hurt on the job because you were negligent, the employer's lawyer can say, yeah, my client was negligent, we admit that, but that's still for workers' comp. There's no jurisdiction here, okay? And so the only way you can get around the vaunted workers' compensation defense is if the employee's lawyer can prove the employer intentionally killed my client. For example, if the owner of a company shoots somebody, well, obviously the owner's going to get sued, but that's very, very rare. And so these very creative lawyers in Philly, they're saying, Your Honor, if we have so many dumb, callous violations and you add them up all together, that should rise to the level of being an intentional act. Therefore, the workers' compensation defense doesn't apply. Therefore, we should be able to sue this meatpacking plant for punitive damages and all this other stuff. The word on the lawyer street is it's a very creative lawsuit. We see why they're doing it. But you know what? We don't think it's going to work. If it works, stay tuned, because that will open up the floodgates, and then all the other lawyers will say, hey, give me a copy of that lawsuit, very creative pleadings, let me try to make it fit here, and let me just file the case and see what happens. But I don't want to be an alarmist. I think there's maybe a 1 in 20, 1 in 30 chance that suit's going to succeed. Okay, let's go into, I see it's 117, let's go into the next section, which is OSHA. I mean, everybody watching this webinar basically knows what the OSHA law is. It's a federal law. It was passed back in 1970, and it's all about safety, okay? The problem with the OSHA law that I see is you can't lump it all together. There are 23 different OSHA statutes. So when you say OSHA to me as a lawyer, it really doesn't mean anything. I mean, there are OSHA laws that pertain to truck driving and underwater demolition and coal mining. The OSHA law that could apply to COVID is called paragraph 11C, okay? So let's talk about that. There are two ways you could get in trouble as an employer under OSHA. One is if an employee makes a complaint that you're not following proper sanitary conditions, you're not issuing PPP and all this other stuff, then the employee can call the OSHA hotline, blow the whistle on you. An investigator will be assigned. They'll do an investigation. They may come out to your facility and check things out and take interviews, and then decide whether or not to issue a citation. Now, at this point, you're not getting sued. That employee can't sue you under the OSHA law. The only thing that he can do is to call the hotline and blow the whistle on you. If the investigator decides not to issue a citation, then the whole thing goes away. If the investigator issues a citation, you can pay the citation, you can negotiate with the investigator, say, okay, you fine me 1,000, will you take 500? Believe it or not, these investigators are real people. Just because they work for the federal government doesn't mean you can't wheel and deal. They're very practical. In my experience, they're one of the more reasonable investigators. They also can spot a disgruntled employee who's just gaming the system. They'll spot that employee right away, okay?
Good.
So you don't really have a lot of exposure if that happens. I'm not saying you shouldn't keep sanitary conditions, but in my experience, you know, the OSHA investigators, they want a smoking gun. They want to see something really bad. Most of the safety complaints are frivolous, or an employee is just trying to be retaliatory, and their fines are generally not that big. And if you don't want to pay the fine, you can appeal it 3 times in federal court. The other aspect of 11C is a little bit more specific. That's the retaliation provision of 11C. That says that if an employee makes either an internal good faith complaint about the COVID virus or about your safety procedures, internal meaning they don't go outside the company, they bring it to the attention of their boss or the company's owner, or if they file a formal OSHA complaint. And then, as a result of that, the company retaliates against them by firing them. Okay, that's called an OSHA retaliation case. Now, that sounds bad, but here's the good part about that. It's very specific. When they wrote the OSHA statute in 1970, Congress decided not to give a private lawsuit right to a retaliated against employee. And that's huge. What does that mean? That means even if that employee could prove that you did retaliate against him because he blew the whistle on you, you brought OSHA in, that employee cannot sue you. That employee has to hope that Department of Labor takes the case. And so if there's a lawsuit for that employee's retaliatory discharge, it wouldn't say Joe employee versus you. It would say United States Department of Labor versus your company, okay?
And that would be in the case that you fire them and they're like, well, this was wrongful discharge and I want a wrongful discharge suit, this is the process that would actually follow.
And
Okay.
the legal term is under paragraph 11C of OSHA, for this type of retaliation, there is no quote unquote private cause of action. Cause of action means lawsuit. That sounds like a technical aspect. It's huge. Why?
Yes.
Well, OSHA doesn't have unlimited lawyers. They pick and choose their cases. And I can be very specific. Last year, actually fiscal year 2019, of all of the OSHA retaliation complaints that were made, OSHA accepted only 0.93% of all complaints.
Wow.
That's right. So really it's less than 100. Now, I'm not encouraging you out there to be cocky and reckless and not care, because you could get in trouble.
Right.
But again, I'm not to say, oh, you know, the sky is falling, we're going to have millions of lawsuits. It's pretty rare for OSHA to bring a lawsuit. Okay. Now,
so,
go ahead.
I have some questions around, because I'm thinking, you know, when I think about people, when I think about managing people, when I think about potential complaints, or when I talk to my clients,
right.
There are people that say that they have concerns because, and I don't know if this falls under OSHA or I don't know, and I need you to understand, you know, like things like, well, I won't come back to the facility, the office, the whatever, because I don't feel safe.
Right.
Or I'm afraid that I'm going to get infected, or I'm afraid if I come back that I'm going to end up getting it and then infect my kids or my elderly parents or something like that. So they're refusing to come back if they are either called back because they were furloughed, or if they were working remote and now are told that they must report back. What do you do with that? Is there a statute that falls under? Or what do you do?
Great question, and that's a real world question. I'll break down. First of all, probably the employee we're talking about is an employee at will, okay? Meaning they don't have an individual employment contract that gives them super rights. Number two, the employee is probably not in a union, and so they can't file a grievance, so they're employee at will. And the law of employment at will basically says the employer is always right, even when the employer is wrong. As the Supreme Court said, if you're an employee at will, this is their language, you can be fired for, quote, a good reason, a bad reason, or no reason at all. So that's the starting point. They have a tough road to hoe. Okay. If they are saying that they really cannot articulate why they're scared, they can't point to anything specific, they're just generally apprehensive. Okay. You literally could say, you know what, I understand that, but you don't have anything specific. I'm ordering you to come back to work. If you don't come back to work, you're fired. Okay. They would have to prove something very, very specific. Okay. I think in most instances, common sense is going to roll. Where I get these calls is if this employee has an immune compromised symptoms, or if they have emphysema, the law calls that an eggshell victim. In other words, a tiny little crack will break the egg. In my experience, most employers are pretty sympathetic, you know, and if you have a workplace where several people have come down with the virus, and then someone else gets freaked out because they have emphysema and they know if they get the virus, you know, they may not survive it. I don't really think that there's going to be any legal issues, because most employers are going to say, well, you know, my lawyer says technically we don't have to give you time off because you can't point to anything specific. You're just generally apprehensive. You can stay home, okay? But in most instances, if you want to, you can say, you know what, just generally apprehensive is not enough. You have to come back to work. Now, it sounds like I'm being cold-hearted or cruel, but, you know, as a lawyer, it's not for me to give a moral judgment. I'm just here to tell you what the law is. Now,
that's important, because, you know, as employers, we want to be as sympathetic and understanding as possible, but there is, you know, I can't, and I'm sure everyone else on this call can't pay somebody forever to not do the work that I've hired them for. So you have to understand what your exposure is in those cases.
Right. Now, I could, you know, as lawyers, I could spin out all these hypotheticals where you could get into legal trouble. We could be here forever. Let me just give you a couple more salient ones. Let's just say this employee has a recognized immune deficiency syndrome, and you do have some documented COVID diagnosis at your workplace, and you have to work in close proximity, and there's a question whether the PPE would be effective. It may be that this employer's lawyer could say, yeah, Kerr, everything you said was technically true, but you didn't think of this. Under the American Disabilities Act, my client's disabled. And you can't change that because he has a longstanding diagnosis of emphysema. And so he wasn't saying he can't work at all. He just wanted a quote unquote reasonable accommodation. And you guys have all heard that.
Okay.
You know, that can be very complicated. Yeah. And his lawyer says a reasonable accommodation in this case would be to allow my client to work from home because I think he could do 90% of his job at home and not come into work. Well, something like that, you know, if you called me and asked me that, I'd say, you know what, I think that employer's lawyer may have something. You know, can this employee do his work remotely? If he can, or if he can do most of it remotely, then you might want to have to give that to him. And if you don't, then he doesn't have a wrongful discharge lawsuit against you. He could file an employment discrimination claim with the EEOC, you know, arguing that you did not accommodate him under the ADA, which just happens to be the fourth category I have here. So again, you know, I know it's frustrating when you deal with a lawyer, he'll tell you a rule and then he'll give you all the exceptions and then you go, well, maybe there isn't any rule. It's all like Swiss cheese. I'm sorry, that's just the way. Okay.
That's why you exist, Larry. You exist so that we can figure out where the holes are for us and where to plug them.
Yeah. Go ahead.
So we did have a question from an attendee, and I think that we probably answered it because it was specifically about somebody who has a proven medical need, and then they're made. What happens if they're called back to work? What it sounds like the answer is that if it can be covered under ADA, if they're protected under ADA, then you have to give them the reasonable accommodation. If they deny coming back to work for the reasonable accommodation, then you can let them go.
Yeah. In order to get the first base with the ADA, if you're a plaintiff lawyer, the threshold is you have to prove your client is quote unquote disabled. And the definition of disability can be kind of squirrely, but characteristically, it's a permanent injury. Having COVID in and of itself is generally not recognized as a disability because it's temporary, okay? Having a cold is not disabled under the ADA. But if I'm not a lawyer, I'm going to say, hey, my client has emphysema. You know that's a disability. Or he has COPD, or he has an immune deficiency, blah, 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 blah. Then if you're a plaintiff lawyer, once you get the first base, you know, by proving your client has a permanent disability of some type, then you can arguably parlay that into trying to get some type of reasonable accommodation. Now, reasonable accommodation doesn't mean the client gets a carte blanche. Okay, here's what I want to do. You know, I want to come in only on these days. No, reasonable means reasonable. There's no, you know, monolithic black-white answer. The law says you have to sit down with the employee. It's called the, quote, interactive process, which basically says you have to talk with them to see if you can work something out that's reasonable, okay? And it's a case-to-case basis. If you're a computer code writer and, you know, you can work remotely, I think the employer's going to have a hard time saying, you know what, he has to be in the office here. You know, because when you write code, you know, you're either in a cubicle at the office or you're at home. And so I think a reasonable, but you know what, if you're in a meat packing plant and the lawyer says, hey, my client has emphysema, he you know, he wants a reasonable accommodation, then just sit home and get paid. You go, no, we're a meat packing plant. You can't work remotely in a meat packing plant. So unfortunately, I can't give you some automatic answer. Let me go back. Go ahead.
So there's another there's another question that's kind of related in this vein about reasonable accommodation, and I think it's related to equal opportunity. Look at me pretending like I know the law, but so the question is, so is it required or suggested to treat all employees the same with regard to allowing for work from home and or requiring them to come to the office? You know, what should you do to protect yourself there?
Great question, and I'm going to give you a typical end-around lawyer run, but it happens to be the right answer. Okay, there's no EEO or EEOC law that says you have to treat everybody the same for everything. Okay. Having said that, as a practical matter, when you start playing favors, you can start to go down a slippery slope and get in trouble. Let me give you an example. Okay, let's just say, give you an example. You have a workplace, you have 10 people that work for you, you only have one African American, okay? And 3 of your white employees wanted a reasonable accommodation. You all do the same thing, say you write code or whatever, and their reasonable accommodation was they wanted to work remotely. And you said, okay, you can work remotely, that's reasonable. And then the black guy asked for the same thing, and you go, no, I'm not going to let you work remotely. Well, duh, you know, he's going to file a race discrimination claim, and he's going to say, look, you know, we're all basically in the same position. We have the same type of job. You let these three white guys work remotely. I'm African American. You didn't let me work remotely. I don't care what your explanation is. Duh, I think it's just, you know, below the waterline race discrimination. Now, very female, over 40 or whatever, okay? And so somebody can make that argument. But get this, they have to pigeonhole their complaint into one of the recognized minority categories. What are they? Age, sex, race, handicap, national origin, or religion. So they have to make an argument that, number one, they got unequal treatment, and number two, there were people not in their minority group who got favorable treatment. The law calls those people comparators. Okay.
Okay, right.
So really, it's either a sex discrimination claim, race discrimination, age discrimination, but it's kind of like an end around run around the ADA. Okay. And so a lot of employers know that, and they go, you know what, I don't want to go down that slippery slope. If I just treat everybody exactly the same, you know, kind of like an overkill type thing, then nobody's going to sue me for minority discrimination. That's true, but sometimes when you have this across the board policy that you don't give exceptions for anybody, sometimes that becomes ridiculous, okay? And so the takeaway is that that person, in order to sue you successfully, they would have to be able to pigeonhole or form their argument that really you not giving them what they want was just an indirect way to discriminate against their minority classification. I should say now that the Supreme Court issued that opinion 2 years ago, add sexual preference to the list. Okay.
Right.
Let me move to the third category. I want to put about 15 minutes into each of these four categories. I left off with OSHA, and I said, you know, even though you cannot be, the employee doesn't have a private cause of action to sue you for the OSHA laws, don't get cocky, okay? And here's why you shouldn't get cocky. It's category number 3, the Pennsylvania Whistleblower Statute. OSHA is a federal law. It applies to all 50 states. The state whistleblower statutes are state by state. Pennsylvania has a nasty one, okay? And let me give you a little preference. I think I'm the first lawyer in the history of Westmoreland County that filed a lawsuit under the Pennsylvania Whistleblower Statute. I'm pretty sure. I've had a lot of them. Chelsea and I have 2 going on right now, okay? They're really complicated lawsuits. There's a lot of money involved, and if you're on the defendant side, you can get hurt pretty bad. What does the Pennsylvania Whistleblower Statute say? Now I have to get technical. First of all, it only applies to you if you're a, quote, government employer. Which means,
what does that mean?
That means if you're a pure private employer, you can say, yeah, I violated the whistleblower statute. You can't sue me because it only pertains to government employer. Aha. What is the definition of a government employer? Well, obviously, number one, it's the obvious government employers. If the employer is a municipality, municipal authority, borough, township, city, county, or the Commonwealth of Pennsylvania, then duh, you're a government employer. But here's the hook. The definition of government employer under the whistleblower statute also includes any private employer who receives at least 1 penny of state or local money. For example,
I'm sorry, does that mean that it's like all of us because we got federal money this year?
Well, not federal money, state money. State money. State
what,
money.
so,
let me give you an example of where most of
okay.
Talk to anybody that works in a hospital or doctor's office, and they'll tell you they're very familiar with the Pennsylvania Whistleblower Statute. Why? Because every hospital, doctor, dental clinic, whatever, they get Medicaid monies, okay? Actually, Medicaid monies start as federal monies, and then they're doled out to the state, but once the state gets them, they become state monies. So basically, you know, you can sue any employer in the medical industry. I'd say probably over half of the whistleblower lawsuits in Pennsylvania are against the medical business, and the medical business is the biggest employer in Pennsylvania. It also applies to any employer out there that I'm talking to that does any type of contract work. with the state, county, government gets any grants, funds, anything. One penny, one apple spoils the whole bunch, okay?
All right.
So,
okay. So I have a question. So that means, so like, I'm also the chair of the Westmoreland County Community College, right?
Yes.
So we get state money.
Yes.
So we would be under that.
Yes.
Now anyone that's a contractor or a vendor with them, that far down, with that, or yes or no?
Yes.
So that vendor would then be
the guy who cuts the grass for the community college is a government employer under the whistleblower statute. Yeah.
Whoa.
Yeah. That's why there are a lot of lawsuits. So, okay, so what does the Pennsylvania whistleblower statute say? It says if an employee files a good faith complaint of wrongdoing or waste, okay, and then as a result of that good faith report, now it can be an internal report to their first line supervisor, the owner of the company, to HR or whatever, or it could be, a report to the police department or OSHA or whatever. But any employee who files a good faith report of wrongdoing and then is retaliated against, the employee can file his own private lawsuits. Private lawsuit against the employer.
So you had said before that we were safe under workers' comp.
OSHA.
Now you're telling us.
That's right. You're safe you're pretty safe under workers' comp. You're relatively safe under OSHA. You have great exposure under the Pennsylvania whistleblower law, okay? And so that's why I want to give you some details on that. The first thing you have to think about is, do I fit? Do I fit into the definition of government employer? Second of all, did the employee make a good faith complaint? Now here's something, as lawyers say, it's pretty counterintuitive. Let's just say an employee blows the whistle on you or makes a complaint and says, I don't think, your PPE is government approved or whatever, blah, 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 blah. And let's just say he's wrong. In fact, it really is. As long as it's a good faith, in other words, if he thinks in his head that it's really not up to standards, then he's covered by the law. And so,
wow.
If you retaliate against him, you can't successfully defend by saying, you know what, we could prove our PPE was up to standards or whatever. You don't know what you're talking about. And so you're not covered by the law. No, it does not require the employer to guess and guess accurately. Okay. So how does an employee prove it? If you want to get into the head of the employee's lawyer, how does he prove it? Well, he's never going to get lucky and get a smoking gun. He's never going to, do discovery and get an email where you're talking to HR saying, oh, this employee is disloyal. He blew the whistle on us. Let's fire him or blah, blah, blah. That doesn't happen. The law recognizes that. So the law fashions an alternative route, which is used in 99% of the cases, and that is timing. If the employee makes his good faith report of wrongdoing on Monday and you fire him on Friday, what do you think his lawyer is going to say? His lawyer is going to say A cause B. It's all about the timing. We have a fancy term for that law. It's called temporal proximity, the time between point A and point B. The tighter the temporal proximity, the greater the inference of causation. The more tenuous or stretched out the temporal proximity, the lesser the timing, okay? And so what does this mean? This means employees, and I'm telling you, employees are very sophisticated. Just because somebody works for you doesn't mean they're dumb or whatever. They can read all this stuff on the internet, and sometimes I'm amazed at how cagey employees are. They know they're going to get fired. How do they know? Because they're on a performance improvement plan. Or they know they're on the bubble, and they want some job insurance. And so what do? They come marching into your office and they say, hey, I want to make a complaint, about COVID, and I think this is a hazard and that's a hazard or whatever. And you talk to your lawyer, and your lawyer says, you know what? You let somebody hang around. I told you this guy was going to get the jump on you. And so now you're telling me you were ready to fire him, but you wanted to wait until your HR director came back and blah, 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 blah. This guy got the jump on you. He made a complaint. And if you fire him now, what do you think his lawyer is going to say? His lawyer is going to say, oh, how coincidental. My client made a complaint on Monday. Oh, and so we were going to fire him in anyway. You know what? You're starting with one hand tied behind your back, okay? And I see this all the time. Employees can be very, very cagey, okay? Now, does that mean you got to fire everybody, right off the bat? No, okay? But on the other hand, if you have an employee, and this not only pertains to COVID, it pertains to employment law in general. If you have an employee who richly deserves to be fired, and you let that employee hang around, or you don't take care of business, you're going to expose yourself to some type of potential retaliation claim. And what that does is that buys at least temporary job insurance. Okay, because what you're going to do is you're going to say, well, you know, we're going to fire him, but you know what, let's hold off for a month or 2 months or whatever. Let's let some time pass, and then we can fire him, and then it won't look suspicious. Well, I've seen employees, they're not stupid. And so what happens? Every month or so, they come up with some reason to complain about something. They keep restarting that temporal proximity clock. And so the takeaway is, once you've determined that an employee cannot be improved, is beyond rehabilitation or whatever, and I know it's horrible to fire employees, even if they deserve it. Nobody likes doing that. But once you make that decision, you got to go out and do it, because the longer you let them hang around, the greater exposure you have to your company. Okay?
Yeah.
Any questions about the Pennsylvania? There's a lot of exposure under this law. It concerns me very much. Okay.
Yeah, it sounds like there is. Right. We don't have any questions about that. We do have questions. I don't know where this falls, or if it falls under any of the laws. We have questions about people who say that they are not able to fulfill their on-site duties because of non-business related concerns, like, for instance, I don't have childcare because of COVID, what kind of protection does the employee have? What kind of protection does the business have? And for goodness sake, Larry, what the heck are us working parents supposed to do in the fall when the schools will not take our children back? Like, I have to say that somehow I feel, and I'm sure anyone on this call right now who is a parent of a school-age child feels like parents are suddenly the most non-essential workers, because we're supposed to magically come up with a way to be able to keep working full-time and figure out what to do with our kids.
Okay. Well, as you know, the FFCRA, which is an expansion of the Family Medical Leave Act, another federal statute, which sunsets on December 31st, gives, in certain circumstances, an employee the right to be paid because he doesn't have child care or whatever. If there's and that can be, I think we actually had the previous webinar on that, and I'm not trying to dodge the question or whatever, but that's like a whole nother area. If there's a specific question now, what I'll do is, Chelsea is our firm's FFCRA expert, and so if there's a specific question, Chelsea will answer that right now. But you'll need to give me a real specific fact pattern.
Okay, so the employee wants to work on site 20 hours a week and at home 20 hours a week, but the needs of the business require someone on site 40 hours a week. But they're saying, I can't come in 40 hours a week, only 20, because I have this child care issue. What do you do?
Okay, Chelsea, take a stab at that.
Well, unfortunately, the FFCRA the paid leave for that only applies if they're unable to work and unable to telework. So if this employee is unable to telework at all, they're only able to work on site due to the needs of the business, then what they're allotted is they're able to, depending on the leave reason, example, if it's for a child, they have no child care, they are allotted up to 80 hours of paid leave. It's at a 2/3 rate of their normal pay. But after that 80 hours is extinguished, they can actually get an additional 10 weeks of pay at 2/3 of their pay but this is specifically for if they need to care for a child whose school or place of care is closed, they don't have child care, etc. But that is all that Leave Act currently allots, is those 80 hours and that 10 additional weeks. So when you had mentioned about going into the fall, I don't think we have an answer for that one yet. What do you think, Larry?
No, I don't think we know.
Yeah, unfortunately.
Okay. And then in this case, for someone says I can show up for 20 hours a week, can they piecemeal that 80 hours? And what happens if the employer is like, well, I can't, 20 hours a week isn't going to help me. I need a full-time person. What do you do?
Well, Larry, I think that would partially be up to the employer, depending on the needs of the business, because it's only applicable if they're completely unable to work and there's no telework. and it would be up to the needs. Larry, what do you think? 'Cause I feel like I'm going in a circle here.
I don't think the employee can piecemeal it. I don't
No.
the way the law stands right now, I don't think they can just say, well, I can be so many hours, but not full time. So I think the employer would have the upper hand there.
Right. I think they would have to at least manage the same amount of hours they had been before.
Okay, so if the employer says, you know, like I can't accommodate that, I would love to, but I can't for whatever reason, then they can have the option to say, you know, you can't work here if you're not able to fulfill this obligation.
Yeah.
Okay.
The employee's lawyer may challenge that and say the accommodation is reasonable, but in general, there's a general principle under the ADA that says that an employee is not allowed to write his own work schedule. Okay, and so that would be our position. That's effectively what he's trying to do, and I think would prevail on that.
Right.
Okay.
Okay. All right. You got another question, or do you want me to move to the fourth and final section, which is ADA privacy? Let me know.
Keep going.
Okay. The fourth category in general is privacy, but specifically ADA privacy. I think most people know what the ADA is. It's a federal law that protects disabled employees and in some cases disabled members of the public. There are two main aspects of the ADA. One we call the public accommodations provision. That's where you get the handicap ramps, the braille, inside elevators, things like that. And the other one that's more relevant to this audience is the employment aspect of the ADA. And as you know, that says that you can't discriminate against hiring disabled people if they can do the job. You cannot fire somebody or retaliate against somebody because they tell you they're disabled and they want a reasonable accommodation. But there's another aspect of the ADA, which prior to the COVID virus was, you know, pretty quiescent, and that is medical privacy. One little provision of the ADA says that if you're going to store health information in your personnel file, you have to keep that segregated. You know what? Most employers don't know that. You know, there's health information in the personnel file. And so if there's information about whether the employee tested positive for COVID or they sent you some test results, number one, you got to store that in a separate file in your personnel file. So if you have the employee's regular personnel file there, right behind it, you might have like, you know, tab A or whatever. Okay. But a lot of ancillary privacy questions have come up. Okay. Because there's an inherent tension with COVID. It's like we're darned if we do and darned if we don't. On one hand, the ADA says we have to keep, you know, somebody's medical information confidential. On the other hand, you know, we have a duty to the other employees to pass the word and say, hey, you know, somebody came up positive, you know, we're, you know, warning, we're up to the red index, you know, everybody be extra cautious or whatever. If you hid that, if you know, like, so in order to protect an employee's privacy, you're just creating another problem. Okay. And so what's happened is the EEOC, which is the federal agency which enforces the ADA, has relaxed the privacy laws. Okay. And has actually been pretty reasonable. Now, I'm not saying that you can blab about somebody's COVID medical information, but on the other hand, you can act reasonably. Like, for example, yesterday I had a business owner call me and say, okay, somebody just came up positive for COVID. We told them, you know, you're going to quarantine for 14 days. You can't come back until you have 2 doctor's slips that say you can come back to work. We would like to tell, you know, the other employees, hey, somebody just came up positive, be extra careful, don't do this, don't do that. But would we be violating the sick employee's privacy if we did that? And my response was, and I think this is supported by the new EEOC guidance, is you can do both. You can put out a memo, and I actually reviewed the memo on my cell phone last night, you know, 10 o'clock when the phone bracket's next to my bed. I'm looking at the memo and I said, yeah, you can say this. And it was just it's a letter from HR going out to the workplace, and it said, one of our employees has tested positive. They're going to stay home for the next 14 days. Everybody be especially vigilant, blah, blah, blah. So what you do is you sanitize the personal identifying information. You know, you don't put the person's name and say what their test results were or whatever. Now, practically, and I told this to my client, I said, practically, I think everybody in the office is going to know who this guy is, but that's okay.
Right.
That's okay. So I see we got about 10 minutes to go, and I kind of anticipated this. And so I'm going to give you the
I have a couple of questions, and then we have some audience questions too. My other question is, like, what happens, or what kind of exposure are you going to provide yourself if you're an employer that decides that you don't want to tell anyone for whatever reason? Say that you're afraid to tell anyone that someone got COVID because maybe that means you have to shut down your facilities for 24, 48 hours, sanitize everything. So, I mean, like, it's irresponsible.
It's a great question. It's a great question. And quite frankly, and I'm not patting myself on the back, but that's why I organized these topics the way I did. Remember the meat packing guy? That's the question. Because the owner of the meat packing plant, you know, he's defending himself now in Philadelphia Common Pleas Court, and he's not admitting he's the devil or whatever. His lawyers are saying, hey, you know what? Yeah, we know we had employees that were positive, but we didn't want to violate their privacy. You know, we're darned if we do and darned if we don't, and blah, 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 blah. And so there is no easy answer. You have to do a balancing.
Okay.
Now, on the other hand, you know, take that to its, what we say, hyperbole, to its extreme. Let's just say, you know, you have a workplace of 100 people and 15 people have come up positive, and you don't tell the other 85 anything. You know, you sit on 15 diagnoses or whatever. At some point, they're going to go, you know what, that's unreasonable. These other employees had a right to know that. But then, as we talked about in the first part of this webinar, if you do get sued, your employers are going to say, you know what, we got the workers' compensation defense, the OSHA laws, you know, don't cover us. And so, yeah, maybe we look bad because we sat on this information because we didn't want to have a panic or a stampede, you know, blah, 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 blah. But you can't sue us because we're immune under this or that. And that's why these creative lawyers in Philadelphia, they said, you know what, let's put together this argument and make all these allegations showing that this employer was extremely reckless, okay? And I'll let you know how that case comes out. But yeah, you're in a paradoxical situation here where, you know, you have to choose. Do you want to protect the employee's privacy, or do you want to sit on that and potentially put your other employees at risk? Choose your poison. Right. Choose your poison. It's a great question. Go ahead.
So we also have another question, and this is not, this is coming back to actually the question about childcare, right, and being able to take that leave. How, and this is actually, like, when we talk about documentation in general, when an employee is making a request or a claim of some kind, not just to this question, but I mean in general, this particular question asks about how far we push the requirement of documentation of not having childcare. But that requirement of documentation can go into different areas, right? Like whether it happens to be the ADA and I have a disability or whatever. In this case, the question is about there are daycares that are open. This person's daycare or whoever they were getting daycare from is not available / closed. So if they just say, well, this one that I usually go to is not open, I want to be able to take advantage of leave versus I'm not taking best effort. You know what I'm saying?
Great question. Okay. At the beginning of the COVID pandemic, all the employers were understandably paranoid and skittish when all these federal laws came out. So at the very beginning, if an employee just said, I don't have any child care, the employer was so paranoid that the employer said, okay, you have to come to work. I'll take your word for it. Okay. And I understand that. I mean, I was paranoid too, because when these two federal laws came out beginning of the year, I told Chelsea, I've been in this business for 36 years. I've never seen any laws like this. They were passed in a stampede. They weren't worked out. Everybody was panicking, to including me. But as time has passed, employers have calmed down a little bit, and they're starting to see some employees are gaming the system. So to answer your question, if somebody just says, hey, take my word for it, I don't have any child care, you can do your due diligence. You can do your own investigation. You can say, okay, well, who did you take your kid to previously? What was the name of that? You know, and you can get on Google and say, okay, well, I've found, and I've had clients do this. I'm on Google, I see where you're at, and within, 5 square miles from where you're at, there are 15 daycare centers. And I just called 3 of them, and they said, yeah, we're open for business and blah, 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 blah. And so you can do that. You can do that. You can do your due diligence. Now, at what point can the employee saying, oh, you're violating my rights and you're supposed to, no, because if push came to shove and you ended up in court, you would be able to prove that this employee was scamming you, or if they weren't scamming you, they overreacted and they just assumed there wasn't any child care. So the short answer is yes, do your own investigation. Confirm to your satisfaction that this employee is not lying to you or not exaggerating. The answer is yes. Go ahead. Okay, let me get go ahead. I want
go
to
ahead.
freely. The fourth category was ADA, privacy, and there are a lot of specific questions, and so you can write this down. Just Google this phrase. What you should know about COVID and the ADA. If you Google that, it'll take you to one of OSHA's websites that has a very, very lengthy question or Q&A section about all these privacy issues. In other words, for example, can you require somebody to give you the actual antibody test showing that they're they have a COVID or whatever, or should you just ask for a doctor's slip? And so there are so many of these questions, and there's, quite frankly, these Q&A are really nice. They're written in plain English, and they cover just about every permutation of what could go wrong. And so if you Google that, you'll get a lot of really good answers. Okay, Leia, I didn't mean to cut you off, but I wanted to say that before we went off.
No. Oh my gosh, there are so many things. I mean, we could probably keep rapping about this for a while. So there are a couple of other questions. One is that Chad actually said that some of the chamber members were calling him and saying that they had some concerns, didn't even know where to get this answer. An employee doesn't wear a mask in the office or facility, and they don't have documentation for other conditions, the CDC guidelines, so they don't have to get the document for stores, offices, et cetera. So I guess it's probably like, them saying that they're asking for a reasonable accommodation to not have to wear a mask, even though it's required because they have a condition. Do you just have to say, okay?
That's in one of the Q&As I just referred to. What it says is you can demand that they produce a doctor's slip, specifically stating that they do not have to wear a mask for XYZ reasons, okay? But one of the reasons I didn't want to gloss over that, some of these are micro-specific, you're allowed to ask for the doctor's slip, but you're not allowed to ask for the actual test results themselves. So I don't want to overgeneralize. I've given you the answer, but if you get one of these questions, go to this Q&A section, and I think you'll get a very specific answer and have a high degree of confidence that it's accurate.
Okay. We have there's a question in the chat, considerations for field-based employees. So the employee does not come to the office regularly, works out of their business, works out of other businesses rather. So are there any kind of certain considerations? For example, if my employee goes into a private business and provides education to adults, or my employee goes into other people's homes to provide care. So if that is, I mean, obviously those people will be at higher risk because of exposure. Should they be thinking about how protecting themselves through policy? Obviously they should be providing ample PPE, but anything else they should be concerned about?
Yeah, I mean, you can give them lawful orders to do ABC. You can tell them you must wear protection. You can tell them, they must use hand sanitizer before they go into the client's home, when they come out. You can direct them that they have to have a test every week. I mean, I'm surprised that the EEOC has actually been very reasonable for employers. They've given, in my opinion, they're giving employers wide latitude to give specific orders to their employees. And I know what happened. The EEOC is a federal agency, and they got the word down from the White House that we're going to be employer friendly until we get out of this pandemic, as far as erring on the side of overall safety. And so I've criticized the EEOC for 36 years, and I think this is the first time they've actually been reasonable. And so if an employee says, I don't want to do this, or I think that's unreasonable, I think you're paranoid with your safety restrictions, 9 times out of 10 that employee is legally wrong. You have wide latitude.
Okay. So and so what it sounds like, if it's like, what should we be doing? I heard very loud and clear that you should have you should make sure that you have an attorney for your company that is well-versed in these laws and its potential exposure, that you should have a good relationship and open discussions about your concerns, and not wait till it's too late, or get stuck in a position and then say, crap, I don't have an attorney, because they're really going to be behind the eight ball. And then I'm also hearing that you should be reviewing your existing policies, whether it's sick or call off or on-site protocols. I know that at our company, we never had any kind of protocol for coming to the office or going on site when it related to like sanitation. And now we have both of those policies, and we've been reviewing them every month to make sure that that's aligned.
Let me give you a very specific piece of legal advice that'll save you a lot of money. You won't have to use a lawyer. Devise a suggestion box, a non-attributional anonymous suggestion box. You can do it electronically, or you can have a box. Because most of the lawsuits that I end up getting involved in started with lack of communication between the employer and the employee. Your employees have tons of really good questions, but a lot of times they're afraid to surface them. And so if you put out a policy that says, you know what, you can, put a suggestion or a question in the anonymous question box, that it'll be out there in front of the HR office, or you can devise some type of email system where you will head off a large number of lawsuits and issues. Again, most of the legal problems I see started with a failure to communicate between the employer and his employees. Most employers think, hey, I have great communications, great relations with my employees. Oh, yeah. If there's a problem, I know they're not afraid. I don't care how nice they seem to you. You're the boss. They have pressing questions or real concerns, or they're really mad, and they're just going to sit on them, and then really get mad. And next thing you know, they go to a lawyer, and next thing you know, you're getting a letter from a lawyer or a lawsuit. Whereas if you could have nipped that in the bud, if you could have, talked through that, you wouldn't get there. And so I strongly encourage you to have some type of a suggestion box for this COVID thing, because I can tell you, your employees they have a lot of questions. They're very concerned about this virus.
That's a really great suggestion. Very smart. We have one more. I wanted to throw this in there real quick because it's a really great question, and that is, if you have your staff in an environment that they're going to come into contact with the public, and so you want to require that on a certain, every 2 weeks, every month, whatever, that they have to go get a test to verify whether or not they are positive for COVID, because we know it's asymptomatic and you want to make sure you get ahead of that. Does the employer have to pay for it because it's a requirement?
Yes. If you're ordering the employee to get the test for work relief reasons, you have to pay for it. Now, hopefully, the employee has some health insurance that'll cover it, or there may be, some publicly funded tests. But if there's no other way to pay for it, and you're directing the employee to do it for work-related reasons, then you have to foot the bill, unfortunately.
All right. Wow, we covered so much information. I know we could keep talking about this because there certainly is so much to talk about and so many different situations you could be in. But we just went over 2 o'clock, and I want to be respectful of everybody's time. And Larry, if anybody wants to have any follow-up questions, would it be okay for them to touch base with you and Chelsea?
Sure, absolutely. And don't quote me on this, but normally we don't charge for the first call. We just do a diagnosis, okay? And so I don't want somebody to be scared that they're going to call me and ask a simple question. Next thing you know, they're going to get a bill from me, okay?
All right, that's excellent. Thank you so much for that offer. And thank you, everybody, for joining us today. Stay safe out there, make good choices, and make sure all those policies and procedures are aligned. Thank you, guys.
I really appreciate it, Leia. Okay?
Right.
Bye.
Yes. Bye.